Good morning, everybody. I wanted to thank you for taking time out of your day to view Diversified Administration's webinar on Letters 226J and its related forms. Today's webinar will be presented by me, Benjamin Davis, Vice President here at Diversified Administration. I'm going to go slow for the first minute or two. I see one or two people still logging in, so we'll give them time to do their thing. In the meantime, I just did want to go through a quick disclaimer. The information presented today obviously is for educational and informative purposes. The information should be considered general in nature and not legal advice specific to your situation. Always, we do recommend contacting an ERISA attorney if you do have any specific legal questions. With that out of the way, let's talk about the letter 226J. We're going to talk a little bit about it, and then we're going to look at the entire process involved. So, as you may know, this letter 226J does come directly from the IRS, and they identify it as that letter 226J here in that contact ID number. The most worrisome thing about this is going to be this proposed ESRP, which is a penalty the IRS says the employee is going to owe due to the ACA reporting, and it's going to tell the year that the reporting is about here. So here we are in 2018, and the letters that are going out just now are about 2015. So people thought, hey, I filed this, I don't have to worry about it anymore. That is definitely not the case. So here's what we're going to do. We're going to look at the entire process. We're going to look at what to do when you receive one of the letters 226J. We're going to look at how to respond using the forms provided by the IRS, which are going to be these forms 14764 and 14765. And then we're going to understand these letters 227, which is what the IRS sends in response once they get these forms back from you. So again, let's talk a little bit about the letter 226J itself. Since November of 2017, so less than a year, the IRS has been assessing these ESRPs, the Employer Shared Responsibility Payments, to ALEs or large employers who don't offer qualifying health insurance to at least 95% of their employees. Now, in 2015, that number is 70%. They did offer a little bit of a transition relief there. But barring that 2015, they're looking for this 95% offer of coverage. When that is not in place, there is going to be a penalty assessed, and that penalty assessment comes in the form of this letter 226J. Now, aside from penalties in the 5, 6, or even 7 figures, the next most worrisome thing about these letter 226J is the IRS only gives 30 days to respond. Now, up till now, all of the letter 226Js that have been sent out relate to an employer's failure to offer that MEC coverage, that minimum essential coverage, to 70% of its full-time employees and their dependents. This is known as the 4980H A penalty. So there's an A penalty, and pretty much everything that's been sent out already applies to that. Now, currently, what's being sent out are 226Js that are in reference to coverage. It was MEC, it was minimum essential coverage, but either it was unaffordable or it didn't provide a minimum value. And that's going to be this 4980HB penalty. Now, regardless of which penalty it is, the A or B penalty, all of the letters sent out either currently or in the past relate to 2015. The IRS is expected to start sending out these 226Js for the 2016 reporting year shortly, followed by 226Js for the 2017 and 18 filings thereafter. So now that we've kind of talked about the letter itself, let's actually talk about what's in it. So inside the letter 226J, at the top you saw the main thing there is that proposed penalty amount. So they're saying, hey, you owe $89,000, you owe $360,000. Along with that is going to be an ESRP table, which actually shows how the IRS arrived at that proposed penalty amount. In that, it's also going to provide a breakdown of the total number of penalties, essentially, that's making up this ESRP payment, the total number of those, both the A and B penalties. In addition to all of that, provides information on how to respond, and it explains how to use the two forms that they include with that letter 226J, the forms 14764 and 14765. So before we talk about the forms 14764 and 14765, which we'll look at in detail shortly, I want to talk about these penalties, these 4980HA and B penalties, because it's these two penalties that essentially make up where the IRS is getting this ESRP from. This is how they say, this is why you're owing tens or hundreds of thousands of dollars. The easiest way to think about it, the A penalty is when the employer is either not offering coverage or they offer coverage to less than 95% of their full-time employees, and at least one of them receives that premium tax credit through the marketplace. Now, if they do offer coverage and it's full-time employees, one of them goes to the exchange, that's going to be a B penalty. Now, if they offer coverage, why would one of the employees go to the exchange? Well, it says here this could be because either the employer, the coverage that was offered was either unaffordable or it didn't provide minimum value. So the A penalties are when they aren't offering sufficient coverage. The B is when they are, but there might be a concern with the coverage offered. Now here's the ESRP summary table. So this kind of shows the amounts that the penalties are going to generate. So you'll see in 2015, the A penalty was $2,080. The B penalty is $3,120. And then each year it gets higher, higher, higher until for the 2019, we see the A penalty will be $2,500. The B penalty is $3,750. Now, this is the penalty, the A penalty. To calculate that, that's essentially going to show the penalty is equal to the number of full-time employees they have minus the first 30. So you're going to take that total number of employees minus 30 and multiply it by the number over here. So for 2015, you take their total number of employees minus 30, multiply that, and that's what their penalty is going to be. Now the B penalty, similarly, it's going to take the number of employees they have minus 30 who receive that premium tax credit, but then you're going to take that for the month. So you're going to multiply that by 1/12 of the amount shown to the right. So even though this is a higher amount, they're only assessing penalties on a per month basis. So you just take that by 1/12 and then multiply it by the month for the penalties. So the interesting thing about this, even though the B penalty has a higher amount, again, remember, this is only done by the month, where this is done for the full year, the penalty under the B penalty can't exceed what the penalty would be under the A amount. And I like to say this is one of the few things the IRS did that makes sense, and this is actually to ensure that the penalty for the B penalty is never going to exceed the A penalty, and that's because they want to make sure that the penalty for employers who offer MET coverage never exceeds the penalty for employers who didn't offer that minimum essential coverage. The scary thing about these numbers is that these penalties are per person. And when you do get one of these 226Js, this is kind of the face you're going to make when you see that. The penalties are really shocking. So let's actually take a look at some of these ESRP tables from clients who've come to us with some of these letters 226J. So we can see here, this is a relatively small company. Their people are in the 40s and 50s on average. We can see here for the penalty, they're only being penalized part of the year. So there's a few months here they're not even getting any penalty. But even with that, this small company penalized for only part of the year, their penalty is more than $50,000. If we look at a little larger company, we see here they had 74 people during the year. We also see they were penalized the entire year, so there were no months here where they received no penalty. In this situation, that resulted in a penalty of almost $100,000. So we can see here these do get a larger quicker. Now, if we take here, this is again a substantially larger employer. We see they've got 240, 250 employees, but we see, hey, they're being penalized all year. They ended up with a penalty of $360,000. Even for a company with 250 people, that's not a penalty that they can just kind of, slough off. That's they definitely have to make sure that that's dealt with. Even though there's penalties of that size, we definitely do say don't panic. The reason is the letter 226J, it's important to think of that as the start of a conversation. The forms 14764 and 14765 allow you to respond to the IRS, to that letter 226J. More importantly, they allow you to contest that proposed assessment of that ESRP. So the 14764, this form is where you either accept the penalty or you contest it. If you accept the penalty, you can include the payment. You can check right here and you can say, yep, that $191,000 that you're saying I owe, you are correct, I owe that. Enclosed at the full payment, here's that $191,000, call it a day. What's much more likely is you're going to contest that penalty. You're going to say, no, I disagree with part or all of that assessment of the ESRP, and there is no payment included. So this is that 14764, but if you're saying, hey, I disagree, you're also going to need to complete the 14765. Now here's a little shot of the 14765, and you'll notice that some months are shaded and some months are not. Each month that is not shaded represents a month that the employer is being assessed an ESRP penalty for that particular employee. So you'll see here, some of these grayed out. It says, say, no premium tax credit. So that month there's no credit. Other months, if you know anything about the codes, you'll know that 1H2A means, oh, we didn't offer this particular employee coverage because they didn't work here this month. So, so the gray shows where they didn't owe the penalties. All these places where there's 1H, there is a penalty. And if you know what that means, you're saying, of course, there's a penalty. If it's 1H, you're basically telling the IRS, we didn't offer coverage, but we're not going to tell you why. Obviously, that's not acceptable to them, so they're going to assess a penalty. The important thing, though, is the second row here. You'll notice there's essentially blank lines under each one of these. That's the place where you're actually going to say, that's not what happened. We actually reported incorrectly. Here's what happened. So this is essentially a screenshot of that same form once it's been completed. And we're saying, hey, for these months here, 1E, 2F. 1E, yes, we did offer coverage. 2F, they waived. So it's saying, hey, for all these months that you're assessing us a penalty, we offered coverage and they waived. Another important thing is over here in this right column, you're going to see it says additional information attached. What I recommend to this company is I said, okay, if you offered that employee coverage and they waived, include that waiver form so you can show that they waived. Additionally, you'll see they stopped offering coverage here, and then it changed from we offered coverage and they waived to we didn't offer coverage because they didn't work here. This individual was terminated in June, so I said also include that June 2015 termination form to show why you didn't offer coverage. And you go down and you do this for each employee. We see here this particular employee, that's an April 2015 application, so this was a new hire. So up till April, hey, they didn't work here. And then 1H2D you'll see for the next 2 months. Well, that means, hey, we didn't offer coverage. Why not? Well, this is a new hire. They're in their waiting period. But then you'll see here, it actually changes to 1E2F. Then we started offering coverage and they waived. So for this individual, they've got that 2015 application showing it's a new hire, and then the waiver form showing they waived. So you do that for each employee, and you say, hey, here's what actually happened. So let's look at this, the conversation now that we've kind of seen a few of the forms, and let's look at what's going on. So the IRS, they send this 226J with that ESRP table. It calculates the fine, assesses the penalty, and provides the information on how to respond. The employer responds with those 14764 and 14765, allowing them to either accept the penalty or dispute it. Once the IRS gets these two forms back, they're going to reply with one of 5 227 letters. Depending on the letter, that penalty is either going to be maintained, partially reduced, or eliminated in its entirety. So let's take a look at these different 227 letters. So one of the things all of the letters do is they acknowledge that, hey, you responded to the 226J. They're also going to provide instructions on what to do about the ESRP. So the 227J is essentially one I've never seen because that's the one that's sent when the employer agrees with the ESRP. It's like, yeah, that $191,000, yep, you are right, we're sorry, here you go, here's the check, and case closed. So they're saying, hey, we got the penalty, go ahead, case is closed. Other than paying the penalty, no response is required. Now, the 227 that you want, the 227K, is what acknowledges that the ESRP has been reduced to 0. So that's the IRS saying, hey, we looked at your response, and you're right, you don't owe anything, case closed, there is no response. So this is the 227 you want if you're disputing the fine. This is the 227 that says there is no penalty. Here's actually a screenshot of a 227K that we got for one of our clients, and it says, hey, we received the response to our previous correspondence about your penalty. We're closing this inquiry because we accepted the information you provided. After recalculating the amount, you do not owe any ESRP. At this time, there's no assessment and no ESRP for the tax year listed above. No action is required at this time. They even say if you sent a payment, they're going to go ahead and send it back. Now, the 227M is the one that you do not want. This is the one that acknowledges receipt of the information. They're saying, hey, we got your response, but we're actually maintaining the penalty. We looked at what you sent us, and that did not change the amount of penalty that we're assessing you. In this instance, you can either agree with the proposed penalty, or you can appeal it once again. So this is a screenshot of a 227M. This is from a client who tried to handle the original 226J on their own. And the IRS basically said, they said, we consider the information you provided, however, the amount of your penalty is unchanged. They actually provide instructions on what to do if you disagree. You can either make a small case request or do a formal protest. If you do not appeal your penalty, or if you lose your appeal, you're going to get something called a CP220J. This is what actually is assessing you the amount of the proposed penalty. Now, if you take a look, everything we've seen now says proposed ESRP. So again, this is really still part of a conversation. They're saying this is what we propose that you owe. If you lose this appeal, or if you don't appeal, then you get this notice CP220J. And you'll see here the notice CP220J. This is just saying we charged you an ESRP. This is the amount that's due. You owe us $231,000. So this is not a proposed penalty. They're not saying this is what we're suggesting you owe. It's like, no, just you owe us. Send that to us. So this is definitely what you do not want. And again, this is from someone who tried to handle this on their own, and we're working to get this resolved for them. One of the other letters is going to be a 227N. If you go to appeals, this is going to acknowledge whatever the result of the appeals is. If you pay the ESRP, or if it's required, it will note that. Otherwise, it will say that no response is required. So that really covers the entirety of the 226J. It shows what's in it, that ESRP table, the 14764 and 14765 that allow you to respond, and the 227s that the IRS can send in response to that, either maintaining the penalty, potentially reducing it partially, or eliminating it in its entirety. If you or your clients have received a letter 226J, obviously contact us immediately. There's that 30-day window, so it's definitely crucial to get that to us. We can file an extension. We'll have contact the IRS. They often give an additional 30 to 60 days to respond. That will give us plenty of time to actually review the information in that 226J. We'll take a look at that proposed ESRP penalty and that 14764 to determine best how to respond. As you saw while we were going over the 14765, we're going to provide a list of supporting documents to include in response, whether it's signed waivers, new hire forms, term forms, or even change of status forms. So I did try to cover the most important parts of the topics related to the letter 226J, and you may have additional questions. Either feel free to type them into the chat window, or if you are connected by microphone, feel free to ask a question. I'll use any of the time remaining to address those. Okay, well, nothing but crickets. So I do hope that means that I was able at least to answer all of your questions. I do appreciate that I was able to help. If you have any questions, definitely do feel free to give us a call. You can reach us at 954-983-9970. You can contact us generally at info@div125.com. You can also contact me directly at Ben, at div125.com. Do always keep us in mind if you ever have any questions concerning our other lines of service, whether it's Form 5500 filings, wrap documents, COBRA, FSA, or HRA administration, summary plan descriptions, welfare plan documents, and more. So thank you everybody for attending, and have a fantastic day.